We don't prevent the federal authorities from coming to our jails or coming to our prisons with a federal criminal warrant and taking them. In fact, I would like them to do that. But it is up to them to go to a court to get that criminal warrant.
It's Governor J.B. Pritzker yesterday at an unrelated event in Jacksonville answering my question as to why the state's migrant sanctuary policies aren't harming public safety. It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and wake up with us here with Illinois in Focus and the Center Square here on YouTube. Get the podcast where you get podcasts. Look for Illinois in Focus. You'll find it. And get the segments of the show as well, and news clips and conversations about things happening across the country at the Center Square here on YouTube. So we've been tracking this federal court case brought by U.S. Attorney General Pam Bondi. One of the first actions she took after taking office in February under the Trump administration was to sue the state of Illinois, Cook County, and the city of Chicago over migrant sanctuary policies that are in place across the state prohibiting local and state law enforcement from cooperating with federal immigration authorities. That's the Trust Act. And then the Way Forward Act went for more and said that you can't have local jail beds be available for immigration detention, and local jails and prisons can't cooperate or communicate the immigration status of any of their inmates. So Pam Bondi sued. Then you have the court process playing out where they went ahead and ultimately asked for the case to be dismissed. And if you go to thecentersquare.com and see the Illinois page, you'll be able to see this story I put together yesterday. DOJ, non-citizen Illinois officials kept from ICE accused of murder after jail release. So here's where we're at. All right. So one of several examples that the U.S. Department of Justice gave of how federal officials were obstructed by Illinois and its migrant sanctuary policies. It involves an illegal alien released from jail, later being accused of murder. And you can actually read this yourself in the statement of material facts that was filed last week. So let's go ahead and pull this up so you can read it for yourself through thecentersquare.com. It's 12 pages long. It talks about federal immigration law is under the guise of federal officials. They talked about the president issuing an executive order about the southern border. You've also got the responsibility for immigration lying with the Department of Homeland Security. They talk about federal agents' authority under certain crimes committed, especially since Congress passed the Lake and Riley Act. That includes mandatory detention for people who are non-citizens committing burglary, theft, larceny, shoplifting, assault of a law enforcement officer, or any crime that results in the death or serious bodily injury of another person. So they've given more authority to ICE to go after those individuals. It just goes on from there. But when you get to some of the examples they lay out, they talk about the Trust Act, they talk about the Way Forward Act, what it ultimately does, and then you have the various, Cook County and the city of Chicago and their policies that have been in place for years, the welcoming city policies and such. But how this has harmed federal immigration enforcement, the Department of Justice in their filing last week in the statement of facts looking for summary judgment. Summary judgment is a legal term in court that ultimately spells out that you've got a question in front of the court, and the plaintiffs are saying, we want our side to win the day. And that's what summary judgment ultimately means. So the DOJ is pushing for summary judgment despite the state pushing for the case to be dismissed. But if you look at, defendant sanctuary policies cause significant harm to federal immigration enforcement and public safety. The section there, they talk about the importance of honoring ICE detainer orders, and failing to do so puts the public at harm. It also keeps ICE from being able to safely detain somebody in a controlled manner, and it gives a couple of examples here. Let me pull this up for you. Going through, there were 4 specific examples they gave. On September 28th, 2024, federal officials issued a detainer request for an alien being held in Cook County Jail for criminal trespass, who was later transferred to Will County Jail for a warrant for the same criminal trespass and also for obstruction of police. Pursuant to the Way Forward Act and Cook County's restrictions, the detainer was not honored by law enforcement officers in either jurisdiction. Following the alien's release from local custody in October of 2024, he was again arrested, this time for aggravated assault of a police officer, gun charges, resisting an officer, obstruction of justice, and criminal trespass. The Department of Justice gives another example of here in Illinois. September of 2024, federal officials issued a detainer request for an alien held at McHenry County Jail on aiding, abetting, and possession of selling a stolen vehicle. The detainer was not honored due to the Illinois Way Forward Act. Following his release from custody in October of 2024, the Elgin Police Department arrested this illegal alien for aggravated criminal sexual abuse of a minor, 2 counts, traveling to meet a minor, and contributing to the delinquency of a minor, 2 counts. In January of 2025, so just as recent as January, a couple of months ago, federal officials issued a detainer request for an alien who is being held in Cook County Jail on sexual assault of a minor charges. Pursuant to Cook County's restrictions, law enforcement officers did not respond to the detainer request. Following the alien's release from local jail, he was arrested and charged with homicide just 17 days later. Just 17 days later. So yesterday, I was able to get over to Jacksonville, where the governor was holding an event talking about downstate grants to revitalize communities, and I asked him an off-topic question about this most recent one, January of this year, an illegal alien being held in Cook County Jail, not being given to ICE, and then being released 17 days later. That illegal alien was arrested and charged with homicide. I asked the governor how sanctuary policies aren't harming public safety.
How is your policy of the sanctuary, migrant sanctuary policies, how is that not harming public safety?
We don't prevent the federal authorities from coming to our jails or coming to our prisons with a federal criminal warrant and taking them. In fact, I would like them to do that. But it is up to them to go to a court to get that criminal warrant to take them away. I would like every violent criminal that is an undocumented immigrant that is in the state of Illinois to be removed from the state of Illinois.
Should there be more clarity on that, though? Because they gave at least 3 examples in the court filing saying that another person went out.
I don't know how much clearer I could be. I've been very straightforward about this. I've said it the same every time. We could talk about the hardworking, tax-paying, undocumented immigrants who are here in the state of Illinois and what we ought to do about them. Those are the people that, by the way, if we had better border control and comprehensive immigration reform, those are the very people we'd want to ask to come to the state of Illinois, the hardworking, tax-paying, law-abiding people. But that's not what we're talking about here, right? These are violent criminals, and as far as I'm concerned, like I said, I welcome the authorities coming with criminal warrants to take those folks away.
So the governor saying that he wants violent criminals to be taken away, but the Department of Justice and Homeland Security and ICE need to come with criminal detainers, not civil detainers. That's an interesting line to draw here, but clearly a line that's been drawn by the governor. So while the DOJ filed their motion for summary judgment and statements of fact to back that up, the state had a deadline of yesterday to reply to a briefing schedule proposal, and they replied late in the day yesterday, ultimately saying that they're asking for the federal court, to delay a briefing schedule, saying that their position is the United States summary judgment motion lacks the necessary things to move forward. They also say that they want to ensure that the court deals with their motion to dismiss this case. So clearly this case is going to continue on in federal court. Just how long, we'll be watching. I'll be checking the docket regularly to see what the judge does in this case, whether they grant a motion to dismiss, or whether they look to possibly move forward with some kind of briefing schedule to tackle the issue of summary judgment against state sanctuary laws. We'll keep it here on this issue, no question. It's Illinois in Focus Daily. I'm Greg Bishop. Like, subscribe, hit that notification bell, and wake up with us each and every weekday morning here with the Center Square.